2, 1.
Oh, yes, oh, yes, oh, yes. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you. Good morning to the attorneys. Welcome to the Court of Appeals. Your panel this morning consists of Judge Armstrong, Judge Davis, and myself, Judge McClarty. If there is any technical difficulties that develop during these proceedings, please let us know immediately so they can be corrected. Also, we will be conducting these proceedings as if we were in court ourselves, except during your presentation, you will not need to stand, okay? Madam Clerk, is there any preliminary matters we need to consider first?
No, Your Honor.
And will you please call the case?
Timothy Lee Malone versus Anthony Viele et al.
For the appellant, you may present your argument.
Thank you. Good morning, Your Honors. My name is Kimberly MacDonald, and I, along with Donald Caparella and Troy Jones, represent the appellant, Timothy Malone. I'd like to request 3 minutes for rebuttal, please.
Yeah.
Your Honors, this is a very simple personal injury case involving negligence, where 3 of the elements of negligence, duty, breach, and causation, all have genuine issues of material fact, precluding the granting of summary judgment. This case involved Mr. Malone, who is the appellant, and Mr. Anthony Viele, who is the appellee, working together on Mr. Vile's cabin in Butler, which was under construction at the time. They were preparing the site for an impending storm, and during the task at issue on appeal, both men were up on ladders, nailing a 2x4 plank diagonally across a very large window opening. Mr. Malone was nailing the top end of the board while Mr. Viele was holding the board in position. And during that task, unfortunately, the board bounced back and knocked Mr. Malone off the board or off the ladder. It is an issue in this case regarding whether Mr. Viele properly executed his assumed duty to exercise that duty with due care, which was to hold the board and to stabilize it. Mr. Viele disputes that his assumed duty goes beyond just the task of holding the board, but it's clear in Tennessee case law that when you assume a duty, you must execute that duty with due care. In this case, common sense says that executing a duty to hold a board in position while somebody else is working on it, especially when both people are on ladders and there's the potential for injury, that must include the duty to stabilize that board. And the trial court erred as a matter of law in construing otherwise, in essentially just finding that the scope of his duty was to make physical contact with the board and nothing further. The Hoynacke case that we cited in our brief is directly on point, Your Honors. It describes how when somebody assumes a duty, which of course Mr. Viele does not dispute, he did so in this case. When somebody assumes a duty, you must assume that duty and execute it with due care. In the Hoynacke case, it involved a father and son duo who was working on an RV. The son was up on a ladder while the father was holding and stabilizing the ladder for the son to safely perform that job. At some point, both the father and son apparently believed that the ladder was secured, and the father walked away to take care of other matters. At that time, the son descended from the ladder and the ladder fell, which then resulted in his injuries. The father in that case made some very similar arguments that Mr. Viele makes in this case, but the Court of Appeals dismissed those. The Court of Appeals held that the father had assumed a duty to hold the ladder and act with reasonable care in doing so, which meant to stabilize it. And it was a genuine issue of material fact as to whether he breached that duty.
Ms. McDonald, excuse me for interrupting. I think the challenge in your situation, though, is your client testified in his deposition that he did not know what what the defendant did wrong. He couldn't identify any negligence on the part of the defendant. He tries to say something differently in a subsequent affidavit, and I'm not sure why the cancellation rule would not apply in that case, because first he says, I don't know anything you did negligent, and then he says, well, wait, now I think you didn't hold the board steady.
Yes, Your Honor. The cancellation rule is something I'd be happy to address. The first thing I would like to point out, though, is that from the very beginning of this case, Mr. Malone wrote in the complaint that Mr. Vile's job during that task was to hold the board in position. He did not simply say hold the board. And so it's not a matter of perception, really, whether he was supposed to stabilize the board, because that's also a matter of common sense that that is the scope of what somebody's duty must be when executing that task safely. But as far as the cancellation rule goes, we explain in our brief that there's the questions that he was responding to in his deposition, Mr. Malone's deposition, were confusing and unclear as to whether he was responding to the question of what did Mr. Viele not do? And that was his testimony, was that every time he was asked prior to that last compound question, which I'll get to in a moment, he had testified he did not know that there was anything that Mr. Viele did. And it's reasonable to construe that as, he didn't throw the board at him, he didn't swing it at him, he couldn't identify that he was doing anything actively, that there was an action being taken place. Whereas the only time he was asked in the deposition, what did Mr. Viele do or did not do, was in the form of a compound question where the answer was unclear as to whether he was responding to what he did or what he did not do, and he simply supplemented that testimony later in his affidavit by supplementing more details about the situation. And again, that was consistent with what he has said from the very beginning, that from the complaint, that it was Mr. Vile's role to hold the board in position.
Okay,
Other than the conclusion that somehow the appellee was not holding the board properly, what other allegations are there in the complaint or any proof in the record that the way in which he held the board caused the bounce back? I know there's a conclusion that that's what caused this to happen, but I mean, what is the specific allegations about what he did or failed to do that caused that to happen?
Yes, Your Honor. Well, we actually are construing the word stabilize as the action and not the conclusion. Of course, it is also the result that hopefully it would prevent it from moving, but the act of stabilizing means to do anything in your power to prevent something from moving, to essentially hold it in position. And so the circumstantial evidence surrounding the fact that Mr. Viele was not holding this board in position, was not taking that action, was the fact that the board had such a wide range of motion that it was allowed to not just reverberate or shift, it swung in such a large manner or wide manner that it knocked Mr. Malone off the ladder. And Mr. Viele has conceded that there is a genuine issue of material fact about how Mr. Malone fell, because Mr. Viele says that he believes he just took a misstep. Mr. Malone says, no, the board actually bounced back with such a wide range of motion that it knocked me off. And this is a solid piece of lumber. It's a 2x4. It's very large, over, an almost 12-foot window opening.
Had it not been, I thought that it had been, there were several he had already nailed several nails into the board prior to him claiming that it bounced back and hit him. Like, I'm not sure.
Yes, Your Honor, that is correct.
How that happens.
So I'm not sure either how it happens. And I think that's exactly why this is a question for the jury that should preclude summary judgment. He was in the process of nailing. I don't remember exactly how many nails were in the board at the time, but the key point there is that he was not completed with his job when this incident occurred. Nobody disputes that Mr. Malone was still working on his end of the board. And that means that Mr. Vile's duty to hold and stabilize the board similarly could not end. That is just like in the Hoynacke case, where both parties believed the ladder to be on stable ground. That's why the father walked away, and the Court of Appeals said, no, I don't care what what you perceived in that moment. The fact of the matter is you assumed the duty to hold the ladder and to hold it steady during the entire time that your son was up working on the RV. And so similarly here, Mr. Viele had assumed the duty to hold the board steady during the entire time that Mr. Malone was working on the board. And until Mr. Malone finished that task, Mr. Viele could not let go.
Let me ask you, Ms. McDonald.
Yes, Your Honor.
Did the board bounce back or did it swing as you indicated earlier? Which is it? Did it bounce back as he was nailing another nail in?
Your Honor, I'm construing both of those in the same fashion, because bouncing back, he said that the board knocked him off. And so that's a wide range of motion, meaning it's swinging against him, is the way that we read it and the way that Mr. Malone perceives it.
Well, what I'm trying to understand, if he had in fact placed one or two nails in before this bounce back, how would the 2x4 bounce back? How could that possibly happen?
Your Honor, I don't know the physics of that. I apologize.
Yeah.
I don't know if these were shorter nails and they required more. Perhaps there's a reason that Mr. Malone and Mr. Viele do this kind of work, and I don't have a cabin under construction. But go ahead.
Whose burden would it be to establish what happened? Is it the appellant's burden or is it the appellee's burden to establish what happened and what caused it to happen? Because I'm having problems with understanding if you had nails in there already, how it would bounce back.
It is, Your Honor, it is Mr. Malone's burden to show that there is a genuine issue of material fact regarding this, and that there is enough in the record to preclude summary judgment. Having nails in the board, I don't know if it was one or two, but this is a very heavy board and gravity works as well. So it could have been that just that action pulled the rest of the nails back, because the reverberations of him nailing in another nail, caused that bounce back. And so he was still in the process of working.
So if it's hitting the nail, hitting the board again with another nail that caused it to bounce back, would that be negligence on the part of the appellee?
Your Honor, it would be negligence on the part of the appellee to not have held the board in position and stabilized it during that task. If there is a question about comparative fault as to whether Mr. Malone contributed to it at all, that would be another, genuine issue of material fact for the jury. That is something that a jury should decide. That is not a question of whether Mr. Viele was negligent at all. It is our position. And so I believe I'm almost out of time. So if anyone has any more questions, I would like to reserve the rest of my argument for rebuttal.
I hear none.
Thank you.
Thank you very much. Yes, sir, for the appellee.
Good morning, Your Honors. May it please the court. My name is Jimmy Rasnick of the Bristol Bar, and I'm pleased to appear before you this morning, although we're not back in person quite yet. I do represent the appellees, Mr. Viele and Ms. Harper in this case. Pardon the pun, but I believe Your Honors hit the nail on the head when you were questioning Ms. McDonald about whose burden of proof it is in this case to show exactly what happened and why my client breached a duty of due care. The simple fact of the matter is that although Mr. Malone was given ample opportunity during his deposition to give some explanation as to what Mr. Viele did or did not do that caused this accident, his best response was, "I just don't know." The trial judge recognized that fact and searched the record carefully for any evidence to support what I submit is a manufactured conclusion by Mr. Malone that Mr. Viele failed to, quote unquote, stabilize this 2x4. I think we do not need to make this case, or the fact pattern in this case, any more complicated than the simple factual situation that it is. I'm sure all of us can imagine these two men up on these extension ladders, and the whole idea is trying to get, because a storm was coming in, this house under construction had this Tyvek house wrap around it. None of the doors or windows had been framed in or inserted, so you had window openings. Well, the Tyvek is a thin sheet of house wrap, and they didn't want, or the owner, Mr. Viele, did not want the storm winds to tear this Tyvek off. So what they're doing is nailing these 2x4s in a diagonal fashion from a bottom corner to the opposing top corner. Mr. Viele admits, and we acknowledge, that he had assumed a duty to hold his end of the 2x4 at the bottom corner. Although it is Mr. Vile's position that Malone's argument that Viele assumed a duty to stabilize the board is a conclusion based upon no substantiated facts in the record, although that is Mr. Malone's position. If you look carefully at his affidavit, which is the only place in the record where that statement or that theory of stabilization is shown, if you look at his affidavit, he claims that Mr. Viele had a duty to stabilize his end, Mr. Vile's end of the board. It was not Mr. Vile's end of the board that moved. Mr. Malone can't tell us what Mr. Viele was doing when the board bounced back after he hit it with a hammer, because Mr. Malone admits he was not looking at Mr. Viele. The only evidence in the record as to what Mr. Viele was doing and did the entire time was to hold the bottom end of the 2x4 while Mr. Malone nailed the top end in. Now, Judge Armstrong, you asked a question that I can't answer either. And I think Judge Davis, you mentioned this. If Mr. Malone had gotten the top end to stick or secured it with one nail, how did it pop out and come out and bounce back and hit him in the head when he hit it with the hammer again? That's what he said happened. He said, I nailed the top end. It was holding. I hit it again and it bounced back, hit me in the head, and knocked me off the ladder. There is no evidence as to anything Mr. Viele did or did not do to cause that 2x4 to do that. Mr. Malone asks this court, what I perceive to make a leap in logic, if you will, and decide as a matter of law that because the top of the 2x4, because Mr. Malone's end of the 2x4 bounced back and hit him in the head after he hit it with the hammer, that equates to negligence or a failure of Mr. Viele in some way or some fashion to exercise ordinary care. I don't see it. I don't think the trial judge saw it. Mr. Malone was given 3 opportunities at least to tell us what happened when he was deposed. I don't know how clearer the questions could be answered. I think calling a question what did Mr. Viele, what did he do or what did he do or didn't do that caused this accident? Calling that a confusing question is a stretch. The simple fact of the matter is Mr. Malone was asked, number one, what did Mr. Viele do to cause the 2x4 to come out? Answer, I don't know. Second time around, do you know if he did anything? Answer, I don't know that he did anything. Third time around, do you know of anything that Mr. Viele did or did not do that caused your fall? Answer, I don't know. A year later, he files a sworn affidavit with what I submit is a manufactured conclusion based upon the fact that that accident occurred, and he doesn't have any evidence that Mr. Viele did or didn't do anything. He comes up with the statement that we failed to stabilize not the board, not Mr. Even if you accept that statement from Mr. Malone, his statement was that his affidavit was that Mr. Viele failed to stabilize Mr. Vile's end of the board. When all you have is evidence to the contrary, that Mr. Viele was doing what he was supposed to do, holding the bottom of the 2x4, and Mr. Malone was trying to attach the top. He hit it with a hammer after it was holding. I'm sorry, he hit it with the hammer one time, it was holding. He hit it again, it bounced back. He cannot tell us what Mr. Viele did or did not do to cause that accident to occur.
Mr. Resident, does the record establish what size nails were being used to do this?
It does not, Your Honor.
So we don't know if they were 8 penny, 16 penny. We don't know that. Is that right?
We do not know, Your Honor.
And we don't know if the first nail or the second nail that was put in, we don't know if it actually went through the 2x4 and into another piece of wood behind it. Do we know that?
We don't, Your Honor. All we know is that Mr. Malone said that he had several nails into his end of the 2x4 to begin with. Now, good question. Does that mean they were all the way through the 2x4 where it would stick quicker, or it was just nailed barely into the end of the 2x4? We don't know, Your Honor.
Okay.
I know I have 5 minutes left, but I mean, that's my argument. I'll be happy to entertain any other questions.
Let me ask you, the Honacki case that the appellant argued, is that in any way similar to the facts in our case here today?
Judge, that was my case, as a matter of fact. I lost. I think Honacki is entirely distinguishable because in Honacki, the defendant failed to continue to hold on to the ladder, which this court said was proper for a jury to decide whether that was a breach of his assumed duty. Mr. Honacki not only stopped holding on to the ladder at the time his son was going to come down, he not only stopped holding the ladder, but walked away. And the facts in that case is that he walked away around the corner of this motorhome that they were waxing. He was not even in the vicinity of the ladder in order to reach out and grab it, to even try to keep it in position, to keep the ladder from falling, to keep his son from falling. I think Honacki is entirely distinguishable because in this case, there is no evidence other than the fact that Mr. Viele continued to hold the bottom of the 2x4 the entire time. He didn't let it go. He didn't walk away.
But Mr. Resnick, in Honacki, the ground was unlevel, wasn't it? And that's why the father needed to hold the ladder, because it was not on level ground. which would.
That's what
the.
I'm sorry for interrupting, Your Honor. I thought you finished. Yes, sir. That's what the court found, that one of the reasons that it was a question of fact whether Mr. Hoynacke breached his assumed duty was because of the evidence that the ladder was on uneven ground, and whether he should have continued to hold the ladder or not was a question of fact for the jury or fact finder.
Anything further, sir?
No, Your Honor, unless any of Your Honors have any further questions, I respectfully ask that this court affirm the decision of the trial court. And I thank you for the opportunity to appear before you.
Thank you. I hear no further questions. For your rebuttal.
Yes, Your Honors. I would like to start out by saying that we are not asking the court to resolve this case on the merits, fortunately. This is a summary judgment case, and so we are just trying to point out that there are genuine issues of material fact that remain. So Judge Armstrong, you actually had a great question there. It is unclear in the record as to how secured this board was into the wall, whether it was actually secured at all, how many nails were in there, the size of the nails. These are all issues that have not been resolved yet in the record and further preclude whether there should have been summary judgment granted on this issue. Simply put, in Tennessee, when you assume a duty to act, which of course Mr. Viele does not dispute, you must do so with reasonable care. In this situation, it means this is a large, solid piece of lumber that is presumably slightly flexible, but not very flexible at all. And it doesn't bend in half to where Mr. Viele could have been executing this duty perfectly, and Mr. Malone also experienced the bounce back he described. It's a two-person job. It's impossible for Mr. Malone to have also held and secured the board while he was nailing it in. And there is sufficient circumstantial evidence in the record to point to this occurring. In Hoynacke, the ladder was not on level ground, and so it was important to hold it steady. And here, the men were holding a presumably very heavy and large 2x4. It's a solid piece of lumber diagonally, and the weight is in the bottom, which is why it was so important for Mr. Viele to execute his duty safely.
Ms. McDonald, I think that the difficulty is no one knows in this case what actually happened. Like, there's no testimony from your client or anybody to show that Mr. Viele did anything wrong. He didn't see him not hold the board steady. He didn't see him do anything. He just knows, I hammered it and it came back and hit me in the head. And how that happened is simply, it's guesswork at that point, is it not? You're just assuming that Mr. Viele didn't hold it steady, but it could have been anything that caused that board to bounce back.
Well, Your Honor, that's actually something, fortunately, that the Hoynacke case also resolves, because not only do we submit that it's similar on the facts, the law applies here too. The court cited with approval another case that expressly said, when you assume a duty to hold an object, it said, quote, a reasonable jury could find that he did not do so with reasonable care because the ladder slipped while he was on it. The circumstantial evidence here is that the board bounced back while he was working on it.
But we know that he didn't hold the ladder. That was not disputed. He was gone. He was not holding the ladder without question.
Right.
Here, we don't know what Mr. Viele did.
And Your Honor, we submit that even if the Hoynacke father had been holding the ladder, but was not doing so properly, with loose hands or something like that, that would similarly be insufficient to grant summary judgment.
Let me ask you one final question. Was it
Yes, Your Honor.
Your client's end of the board that bounced back?
Yes, Your Honor, it was.
All right. Thank you.
Thank you. We request that this court reverse the summary judgment on all grounds, and I defer to my brief for the rest of the arguments. Thank you.
Thanks to both of the attorneys for your presentation. Your case is now submitted to the Court of Appeals. You will receive our opinion and resolution of this matter within a reasonable period of time. Thank you very much. Madam Clerk.
Thank you, Your Honor.
This honorable court is in recess until 10:30 a.m.
Thank you. The attorneys may be excused.
Thank you.